Teams naikkan harga dia ke? Or, I don't know lah what happen in the future, harga petrol naik mendadak ke, others harga elektrik naik ke, then we have to reconsider lah. But so far it's okay. I do not have plan to increase anything at the moment. Okay, we run by at a very limited budget. So I do not expect a 5-star punya service lah. Okay, anyway, so are we going to do the class for 2025 as well? As long as my answer is as long as there is a demand, we will keep on doing it because we are doing it for to share the knowledge with everyone and not to make profit lah. Okay, all right. The objective of the webinar, it is as a platform to encourage an interprofessional dialogue within the construction industry community and to provide affordable peer learning in relevant law related to the construction industry. For information, IR 2024, it is a BM pre-approved CPD program. We already got this CPD application granted by BM. Yeah, so one session you get 3 CPD hour. 3 CPD point lah. So if you join 19 session, you get 57 CPD point already. So no need to think about where to get your 50 CPD point anymore. So we'd like to thank Board of Engineers Malaysia, Suruhanjaya Tenaga Indah Hotel Consortium, JPS, JKR, JKKP, University Technology Mara and the Infrastructure University of Kuala Lumpur for their direct and indirect support for our effort to conduct IR 2024 class. Okay, reminder to everyone in compliance with Copyright Act 1987 or Act 322, no form of digital audio photographic recording is allowed, either for distribution, display, or personal keep. Participant microphone is muted by default because I do not want 100 people to be speaking at the same time. Participants may ask questions or respond to the webinar via the chat box. We have a chat box, so you can type your question, anything there. So I will have a look. Sign out link, sign out form link for CPD Clear will be shared in the chat box at the end of the webinar. At the same time, we will also share on the screen the QR code for you to just scan and fill in the information. Okay, about the organizer, I'm not covering this because I've already talked about this last week. Okay, now we enter on the hierarchy of law in Malaysia. Myself as an architect, we are all in consultants in the construction industry. We have a common problem. Not just architects lah, engineers ke, town planner ke, and quantity surveyor ke. We have this one problem. Okay, because we are technical people. Okay, we are people, technical people where we talk with numbers, we talk with visuals, figures, rather than text. Okay. So I am aware that people within our industry, we do not read. Anybody can proudly declare that they have read National Land Code cover to cover. Tak ada kan? Or Act 133 cover to cover. Very rare to find. Okay, I can tell you honestly, I read National Land Code cover to cover twice. Okay, after you have read the law cover to cover, only then you understand the whole process, what does the act is about. Because if you miss one section, you miss the whole point. Nanti dalam National Code saya bagi tahu what do I mean by this. Okay, but first you have to understand how does the law in Malaysia works. Sebab saya selalu tengok lah consultant wherever you are lah, I'm not criticizing anyone because I come from a family of engineers. My father, my brothers, everyone is an engineer. I'm the only one who is an architect. So many consultants, they do not understand law and how does the law works. While this construction industry is controlled by the law of Malaysia. If you do not know the law, you cannot perform correctly as a consultant within the industry. Okay, let's go to the hierarchy of law in Malaysia. You have to understand this sequence first. Okay, the highest law ever in this country is the Federal Constitution. Perlembagaan Persekutuan. There is no law that is higher than the Federal Constitution. Federal Constitution is absolute. Okay, it is the terms and condition as a Malaysian. It describes how does the country works, what you can do, what you cannot do. Okay, any country in this world has its own constitution. You go to Japan, Japan has its own Japan constitution. The UK has its own UK constitution. Okay, once you agree to become the citizen of that particular country, it means you agree to comply, to abide to everything stated in the country's constitution. Okay, so when you apply for your IC when you were 12 years old, you have to tick the box saying that I hereby agree to become the citizen of Malaysia and dia ada tulis siapa ingat masa buat IC umur 12. And apa kita punya rukun negara? Keluhuran perlembagaan. This is what it means. You comply, you agree to comply everything whatever is stated in this federal constitution. I mean that you agree. It's a terms and condition. You want to become Malaysian? Yes, you agree with this condition. Masa kita buat IC dulu umur 12, kita kena tick the box. Dulu lah, I'm not sure how the procedure is now. But I remember those boxes. I remember those boxes. Tu yang saya tanya, oh yang perlembagaan ni yang kita sebut keluhuran perlembagaan dalam rukun negara tu ke? Itulah. It's a terms and condition. So every single Malaysian, you have to read this federal constitution at least once in a lifetime for you to understand how does this country works. If you don't read this, the consequence is what is happening out there. People do not know what they are talking about. What are the things that they can say? What are the things that they cannot say? What are the things they can question? What are the things that they cannot question? I repeat again, whatever is stated in this federal constitution is absolute. The word is absolute. Who made this federal constitution? Is it the federal government? The answer is no. Is it politician? No. Ramai orang cakap, oh negara kita ni berpecah belah sebab politician. Politician buat macam ni, politician buat macam tu. No, it is not the politician. Politician can only do whatever is stated in the federal constitution. If it is allowed under the constitution, then it is allowed to be done in this country. It is not wrong. Even if you go to International Court of Justice, you cannot win. You cannot win against a country's constitution. Impossible. Okay, who made this constitution? Why I say that it is impossible to win? This constitution was made by the owners of this country. The owners of this country. Who are the owners of this country? We have to reverse back to year 1948. Even before 1948. Kita belajar sejarah dulu siapa belajar ingat sejarah tingkatan 2, pembentukan ke arah kemerdekaan and all those topics lah. Okay. So, long ago, before Malaysia, before Persekutuan Tanah Melayu, before North Borneo or whatever else, before all that, this region consists of different countries. Okay, different countries. Kedah is its own country. Perak is its own country with its own sultan. Kedah ada sultan dia sendiri. Johor ialah negara dia tersendiri, ada sultan dia sendiri. You know, when there is a sultan, meaning that it is a country, it is a state. Okay. The situation back then was that every single state that forms Malaysia today, back then they were an independent countries. They have their own constitution, they have their own sultan, they have their own ruler, they have their own law. So when the British came in, then it creates the formation of, masa tu dia nak buat Malayan Union kan, lepas tu semua orang kita bangkang, tak nak. Say no to Malayan Union waktu tu kan. Okay, so apa yang berlaku ialah pembentukan Persekutuan Tanah Melayu at that time. Okay, masa tu under pemerintahan British. So all these sultans, all these sultan yang kita sebut Majlis Raja-Raja Melayu hari ni, they are the ultimate owner of the land. They own the land. Okay. I give an example. Let's say, for example, I live in Selangor. Selangor has a sultan, Sultan Selangor. Who owns all the land in Selangor? The answer is Sultan Selangor according to the Federal Constitution. Okay. To whom that you pay your cukai tanah tu? You are living on a land, so you have to pay tax, correct? quit rent lah, cukai tanah. To whom that you pay this quit rent to? If you want to claim that this is your land, you have a land title document saying that, oh, architect Amy is the owner of this land. No, my name is only the proprietor on this land, but the ultimate owner of the land is the Sultan of Selangor. At any time, he can just kick me away and ambil balik tanah lah to acquire back the land from me at any time. It is stated under the Federal Constitution. Yeah. So why does the name of this land known as Persekutuan Tanah Melayu at that time? Because the owner of the land are this Sultan, Kesultanan Melayu, the Malay Sultanate. That is how the origin of the word Kesultanan Melayu Melaka lah, whatever lah dulu lah. They are the ultimate owner of the land. So sebab tu siapa yang dulu ada pernah keluar isu kat newspaper, dia kata, weh apa ni, nama jalan ditukar kepada Jalan Sultan whatever, panjang lah nak sebut. Hello, you are talking about the owner of the land. The owner of the land can kick you out anytime. Who are you? You are living on his land. You see what I mean? Itu yang tertera dalam Federal Constitution. Sebab itu ada perkataan dibuang negeri. Any state ruler, I mean sultan, raja yang dipertuan negeri has the ultimate right to kick you out from dia punya territory lah. Okay, alright. So now you understand the ultimate owner of the land are the Malay Sultanate. That is for Peninsular Malaysia. What about for Sabah and Sarawak? Who are the owners of the land? Okay, the owners of the land are the natives, the representative of the natives of Sabah and Sarawak. Sebab itu dekat Sabah dan Sarawak dia ada tanah adat. Okay, tanah adat. Only the pribumi, Bumiputra Sabah dan Sarawak saja, they can own those lands. For example, I'm a Bumiputra, I'm from Selangor, for example. I want to go to Sarawak to purchase tanah adat. I claim, hey, I'm a Bumiputra as well. Cannot. You cannot do that. Tak boleh, tanah adat memang tak boleh. Hanya untuk orang situ saja. So does it mean that Sarawakians are racist because only tanah adat je yang boleh dibeli oleh dia punya Bumiputra asal dekat situ? Orang lain tak boleh. Are they racist? The answer is no, because it is allowed under the Constitution. Federal Constitution said yes, you are allowed to do that. So you are not racist. Ingat, like I said, once you agree to become the citizen, you have to agree everything that is stated under this Federal Constitution. Okay. Another word I want to highlight because related to today's National Land Code. The word, apa nama tu? Do not take this negative way. I'm not talking about politics or whatever. I'm just clarifying this term. Actually, this term is not racist at all. Okay. Siapa pernah dengar perkataan Ketuanan Melayu? Ketuanan Melayu, Why many people think that this word is racist? Okay, I will explain to you what does it actually means. The word Ketuanan Melayu, what is the word tuan tanah in English? Landlord. Landlord, is the word landlord demeaning? No, landlord just literally means tuan tanah. Landlord, landlord, tuan tanah. So when you do the direct translation, it becomes tuan tanah. Okay. And Tuan Tanah, in the context of Persekutuan Tanah Melayu at that time, Tuan Tanah is the Malay Sultan. For example, I live in Selangor, the owner of the land, meaning that the landlord is Sultan Selangor. And Sultan Selangor is a Malay. This term, the Malay Sultanate, was given by the British. That's how the word Ketuanan Melayu came from. It doesn't mean that, okay, I'm a Malay myself. It doesn't mean that I am Tuan, bukan, not me. The Sultan is the Tuan Tanah. Faham? That is the context of the word Ketuanan Melayu. So, I would like to urge my Malay friends lah, janganlah perasan kata, weh ni Ketuanan Melayu, aku Melayu jadi aku tuan. No, that is not the meaning of Ketuanan Melayu. According to the Federal Constitution, Ketuanan Melayu means tuan tanah lah, landlord. And the landlord is the Sultan of each state. Faham? Maksud dia? So, semua orang kena faham lah maksud dia. Janganlah kata, do not misunderstand things and then make an issue out of nothing. That's why I said you have to read the Federal Constitution, then you understand, oh, ini maksud dia. Yeah, alright. So what are the things that states under the Federal Constitution? I give an example. Workforce. Under Article 8 of the Federal Constitution, it states that when it comes to workforce, no form of discrimination on race, religion, gender is allowed except with whatever is allowed under the Constitution. I give an example. Saya banyak tengok dekat Facebook iklan daripada engineering consultancy practice ataupun architectural consultancy practice. Jawatan kosong. graduate engineer. Lelaki sahaja. It is not allowed under the constitution as per Article 8 of this federal constitution. Lagi-lagi jawatan. Jawatan kosong setiausaha pejabat. Wanita sahaja. Tak boleh lah. Cannot. It is illegal. Illegal, tak boleh, because it is clearly stated in this constitution. When it comes to workforce, you cannot discriminate people by their race, religion, or gender, except with what things that is allowed under the constitution. I give a scenario where such discrimination is allowed. Okay. Jawatan kosong imam masjid. Imam masjid. Lelaki dan Muslim sahaja. Is this wrong against the federal constitution? The answer is no, it is not wrong, because untuk jadi imam masjid, you have to be a Muslim. So, when you discriminate the job description, okay, ni syarat-syarat siapa nak jadi imam masjid. Syarat pertama, Muslim. Nombor 2, lelaki. That is not discrimination. That is allowed under the constitution, because an imam cannot be a female. Dalam Islam, imam cannot be a female and it cannot be a non-Muslim. Lagi-lagi saya bagi contoh. Jawatan kosong Padri Catholic Church. Dia tulis Catholics and male only. Is it wrong under the constitution? The answer is it sounds discriminatory, but it is not wrong under the constitution. Because in order for you to become Catholic priest, you have to become a Catholic. Second, you must be a male priest. So I cannot go to court or to social media say, wait, this is unfair. I want to this job offer is discriminating. I want to become a Catholic priest as well. Tak boleh lah. Okay, that kind of discrimination is allowed. Lagi contoh, jawatan kosong ibu susuan. Ibu susuan dalam English apa? Tak tahu apa dalam English. Ibu susuan. Wanita sahaja. Is it wrong to discriminate people like that in job description? The answer is no. Ibu susuan must be a female. A male cannot be ibu susuan. Understand? So there are things that is allowed and not allowed under the constitution. So you have to read this whole federal constitution in order to understand the context. After you read cover to cover, only then you will not be making silly statements. Yeah, you will be making komen-komen yang tidak sepatutnya dan memalukan diri lah, because the answer is already in the federal constitution. Lagi satu macam isu sekolah. Kita ada isu sekolah macam sekolah jenis kebangsaan Cina, sekolah jenis kebangsaan Tamil. Ada orang marah, weh apa ni buat sekolah, apa ni tak cakap bahasa Melayu lah, apa cakap bahasa apa ni bahasa Cina dan bahasa Tamil. Hello, the federal constitution allows it. Federal constitution kata boleh, dan boleh lah. Remember, when you become a Malaysian, you agree with the terms and condition. 100% you have to agree with it. Sebab yang buat undang-undang tu siapa yang buat federal constitution ni? The owner of the land. Terdiri daripada Majlis Raja-Raja Melayu, the representative of the natives of Sabah and Sarawak. The owner of the land made the law. If you want to live within their land, you have to comply to the law that they made. Saya kata, like I said, back to the first question, even if you go to ICJ ke Mahkamah Antarabangsa, you cannot win. Because you yourself agree with the TNC. When you decided to become the citizen of the country, you agree with all the terms and conditions. Itu maksud dia. Yeah, alright. So that's the federal constitution for you. Now, why I emphasize on this? Because this is closely related on land matter. Okay, alright. So hierarchy of federal law in Malaysia. In Malaysia, there are two set of law. One is federal law. The second one is state law. Undang-undang Persekutuan, undang-undang negeri. You have to be able to differentiate these two. Okay, for federal law in Malaysia, the highest is the federal constitution. There is no law that is higher than the federal constitution. Okay, a question. Can the federal constitution be changed? Can you change anything inside the federal constitution? The answer is yes, but almost impossible, because to change anything inside the federal constitution, you have to get the approval of all the owner of this country. Owner of these lands are the Malay Sultanates, Majlis Raja-Raja Melayu. There are 9 sultans. You have to go through one by one. Hello, saya nak ni. Hello, saya nak ni. And then the natives of, excuse me, Sabah dengan Sarawak, the representative of the natives. Yang ni dah belajar lah masa kita sejarah, subjek sejarah dulu ya. Okay. Apa tu lagi, another thing about the federal constitution that you have to know, for example, isu macam, there are certain states in this country, dia kata, weh, apa ni, kerajaan persekutuan, ambil minyak daripada certain negeri, macam contoh negeri-negeri Pantai Timur lah, dekat Kelantan, Terengganu, ambil minyak, tapi kami tak dapat royalty, rakyat ke Terengganu dan Kelantan, saya bagi contoh saja, bising. Weh, ni kerajaan persekutuan Petronas ambil minyak daripada Kelantan dan Terengganu, tapi tak bagi dekat rakyat royalty. Hello, before you protest, read the federal constitution first. Does the land belongs to you, the normal people, the commoners? No, the land belongs to the Sultan of Kelantan, Sultan of Terengganu. So if Petronas come to take the petroleum or whatever it is from that state, it is a deal between federal government and Sultan Kelantan or Sultan Terengganu. They made a barter trade. Both agree, okay, I give you this, you give me that. Fair. So yang rakyat kat bawah-bawah ni nak bising-bising, kenapa? The land does not belong to you. Faham tak? Okay. Sama macam isu dekat Sarawak. Okay, dekat Sarawak saya tengok dekat Facebook, saya tengok yang tulis-tulis komen ini mesti yang tak baca Perlembagaan Persekutuan ni. Okay. When the formation of Malaysia in 1963, both sides, ni I'm talking about the context of Sarawak. Sarawak, dia buat agreement dengan Persekutuan Tanah Melayu, kata, hello, jom lah kita combine lah, I want to join you, and then we form Malaysia lah. Lepas tu Sabah pun dia nak join lah. Okay, so when they want to merge, they want to come in and merge to become a new country as Malaysia, they make an agreement between Persekutuan Tanah Melayu that time, together with the state of Sarawak. Okay, they buat agreement. Okay, hello, Malay Sultanate. I want to make a condition in the federal constitution when we merge to become a new country. I can go to Semenanjung, but people from Semenanjung, if they want to come into Sarawak, they have to get a permit. But if Sarawak people want to go to Semenanjung, they no need a permit. So the Malay Sultanate say, okay, we agree. If you want to go to your state, we must get a permit. But for you to come to our state, no need any permit. Okay. Is it fair? Do you think it is fair? Saya nak pergi Sarawak, saya kena dapatkan permit. Kalau dekat airport tu dia tak stamp permit masuk tu, saya tak boleh masuk ke Sarawak. And then another thing, people from Semenanjung cannot simply work in Sarawak, for example. But people from Sarawak, they can freely work in Semenanjung. Is this fair? If you don't read the federal constitution, you will think that, it is unfair. Apa ni? Sarawak boleh masuk kita tak boleh pergi sana. No. Read the federal constitution, what does it say? It is an agreement of both parties. It's a contract. Okay, so Semenanjung gave something to Sarawak, Sarawak gave something back to Semenanjung. So same goes to the issue of the petroleum in Sarawak. Sama juga. Sarawak government, I simplify the situation stated under the federal constitution. Sarawak government, they do not have the technology to bring out the oil. Okay, masa tu zaman British pakai yang jenis putar bawa keluar petroleum tu dekat Miri ada dia punya museum dia tu. Okay. They do not have the fund, the technology to bring in. So, state of Sarawak, they ask for assistance from Semenanjung punya company lah, for example Petronas kata, hello Petronas, Shell ke whoever lah, dia buat agreement. I give an example like Petronas, hello Petronas, can you come and assist our state to take out this oil because we do not have the technology yet. Petronas said, okay, they bind an agreement. Petronas together with, I'm talking about the context of Semenanjung and Sarawak lah. They made an agreement, okay, in return we want this. Fair enough. It is an agreement by two party. So why are these common people yang dekat bawah macam kita ni, why are you protesting? Weh, apa ni, Malaya ambil minyak kita, Malaya kejar. No, it is an agreement by both party. If you're the person you want to, you have no right to question at all. Because you are not the owner of the land. Faham tak? You are not the owner of the land. Kita ni rakyat biasa saja, makan kais pagi, makan pagi. So janganlah masuk campur tanah yang bukan kita. Kalau macam tu saya pun nak claim. Saya, I'm originally from Kedah. Saya daripada Kedah. Mana pergi beras Kedah kita import kan. Jelapang padi Malaysia kita import pada negara luar. Saya pun nak royalty beras Malaysia. Tak boleh lah. The royalty or whatever is a trade between Sultan of Kedah and the federal government. Whatever their deal is, up to them. Kita kat bawah ni hidup macam biasa je lah. It doesn't involve our property at all. Okay. So the hierarchy, the highest is federal constitution. So below the federal constitution, at the second level, there is something known as acts. Acts consists of acts and codes. For example, Act 138, the Registration of Engineers Act 1967. Code is like penal code, kanun tanah negara, the National Land Code. Acts and codes, they are at the second level. Dia berkuasa dia sama. It is known as acts. Okay, and then at the third level, these acts and codes, it gave birth to smaller set of law known as subsidiary legislation. Example of subsidiary legislations are rules, regulations, order, bylaws, and whatever else. I give an example. Registration of Engineers Act 1967 gave birth to Registration of Engineers Rules 1990. So which one you should be reading first? You should read the act first because the act is higher. And this act, it gave birth to subsidiary legislation. Okay. At the lowest level, ya ni kalau macam kita buat piramid, Federal Constitution ni macam Firaun ke atas. Acts and codes ni golongan bangsawan. Rules apa ni, subsidiary legislation is commonness macam kita. And lastly, yang paling kecil kat bawah ni hamba abdi lah. Okay, guidelines, circulars and standards. Yang ni paling bawah sekali level dia. Okay, example, garis panduan perancangan skim perumahan komuniti strata, for example. Garis panduan perancangan kawasan sensitif alam sekitar. Okay, garis panduan. Circulars ke, standards, I'm referring to Malaysian standards lah. Okay, I'm referring to Malaysian standards here. So, this is how we should be reading the law of Malaysia. You read the higher one first, then you go to the lower ones. The mistakes that people in the construction industry, they did is that they read the smaller one first. Lepas grad ni, baru lepas grad pada universiti, terus baca. Senior kata, kau baca Malaysia Standard 1183, pergi baca. No, don't read the lower one. You have to read the higher one first. If you read the lower one, then you will get confused. What is going on? You have no idea. Apa benda ni dia macam pening, tak faham. Because that is not the correct sequence. Okay? Federal Constitution, Acts, it gives birth to subsidiary legislation. And lastly, yang paling kecil-kecil ni lah, guideline, circular, standard or whatsoever. Okay? So let us use the correct terminology. Every single item inside the Federal Constitution is known as article. Article 1, Article 2, Article 3. Kalau dalam bahasa Melayu, dia ialah perkara. Perkara 1, perkara 2, perkara 3. Do not use any other term. Okay, next. For acts and codes, every single item inside an act and a code is known as section. Section 1, Section 2, Section 3, Section 1000, Section 9999. Jangan sebut clause lah. Apatah nama, macam-macam nama orang bagi, geram pula saya dengar. Salah, the name is section. Section 1, Section 2, Section 3. Ingat, jangan sebut perkataan lain. Next, for subsidiary legislation, for rules, regulation, order, bylaw, and whatever else, macam-macam nama, subsidiary legislation. Every single item inside a rule is known as rule. For example, rule 1, rule 2, rule 3. Regulations. Every single item inside a regulation. Example, Registration of Engineers Regulation 1990. Every single item inside a regulation is known as regulation. Regulation 1, Regulation 2, Regulation 3, Regulation 4, Regulation 1000. Jangan sebut clause lah, section lah. Especially the word section. You cannot use the word section to this set of law that is at the low end. Dia macam, if your title is Encik, I cannot address you as Datuk Seri. Macam tu lah. So same, you cannot use the word section to bylaw or to order regulation ke dekat kat lain. You cannot use this word section to that. It is a higher title. Okay. Order pun sama. Order 1, Order 2, Order 3. What about bylaw? There's so many bylaws out there. The Uniform Building Bylaw 1984. Strata Management Bylaw 2015. So many bylaws. So every single item inside a bylaw, building bylaw ke whatever bylaw lah, is known as bylaw. Bylaw 1, bylaw 2, bylaw 3, bylaw 4, bylaw 5. Jangan sebut section. Jangan sebut clause lah. Macam-macam nama saya pernah dengar. Okay. When you quote the correct term, then, people will see you that, okay, you know how things work. You know the law of Malaysia. Yang ni main cakap je. Clause lah. And ada, saya pernah pergi Jabatan Bomba dan Penyelamat Malaysia, Bomba. There was a letter submitted by this consultant from which field I don't want to mention lah. Okay, and then dia tulis kat situ dalam surat tu in reference to section 146 of UBBL 1984, pegawai bomba tu terus marah, dia ambil gambar, dia upload ke Instagram dia. Dia kata apa ni consultant, section dia sebut untuk bylaw, you cannot use the word section for bylaw. Bylaw ialah bylaw, bylaw 1, bylaw 2, bylaw 3, bylaw 250 ke apa. Okay. Okay. What about for guidelines and circular? I put a question mark because, not because I do not know, but it depends on that particular document itself. Some guidelines, some circular, it is known as item. Item 1, item 2, item 3, ada yang tulis paragraph, paragraph 1, paragraph 2, paragraph 3. So each of the documents will self-declare itself, so we just have to refer. Lagi standard, Malaysian standard lah, MS 1184, MS 1183, MS 2680, MS apa lagi yang kita selalu pakai for PSP lah, for SP ke, MS 1525. MS, tak tahu tak, macam-macam lah, MS 9999, whatever Malaysian standard you're referring to. Every single item, excuse me, inside the Malaysian standard is known as clause. Memang dia tulis clause dalam tu, clause 1, clause 2, clause 3. Kecuali kalau siapa pernah jumpa Malaysian standard yang dia tulis nama lain. So far, the one that I've read itu memang clause. Okay, what about the conditions of contract? Whatever contract, excuse me, that you're doing. PAM contract 2006 ke, your sales and purchase agreement ke, your employment contract, your prenuptial contract between husband and wife, apa lagi contract yang ada, hire and purchase contract, apa-apalah, whatever contract that you're doing in this country, every single item inside the conditions of the contract is known as clause. Siapa yang rasa gian sangat nak pakai perkataan clause tu, sini tempat dia. Unless stated otherwise in that particular contract. I repeat again, unless stated otherwise in that particular contract. Okay. Alright. Where to find all this law of Malaysia from? It is free for everyone. Percuma sahaja. Long ago, sebelum ada internet, law of Malaysia is accessible at library, perpustakaan bergerak, dekat perpustakaan awam, perpustakaan sekolah dan macam-macam tempat lagi lah. At the local authority, dekat jabatan-jabatan kerajaan, it is free for people to come and read the law of Malaysia. But after the existence of the saya tengok ada gambar jata negara dekat situ. Logo harimau 2. So, this is legal. You can download for free. Tak salah. Okay, and then any update, be it an act, maybe an amendment to federal constitution or subsidiary legislation, within 7 days of such amendment or gazette or whatever is happening, any changes, they will upload it immediately in this portal. Okay, the website is LOM. LOM means lawofmalaysia.agc.gov.my. So nampak ada kat situ dia tulis Federal Constitution, Act, Subsidiary Legislation. Where does all this term come from? Dekat website ni lah. Nampak tak? Federal Legislation ni yang mengajar kita. Ni dia punya hierarchy of law. Yang ni dia. Kat situ dah terang-terang. Okay. So for example, when you click on the word Act, nampak tak? The latest act is Act number 854, which is the Cyber Security Act 2024, gazetted on 26th of June. Ni baru lagi, fresh from the oven. Baru sebulan keluar. Akta baru. Lagi sebelum tu, Jurisdictional Immunities of Foreign State Act. Benda dah ditulis tu. Control of Smoking Product, whatever lah. You can download in Malay and in English. Kenapa BM dulu dan baru English? Because the language, it is the national language. It is the national language. So the BM will, the BM will supersede the English one. BM will supersede the English one. Okay. Kalau ada discrepancy, confusion, read the Malay one. Okay, ya nampak tak? Boleh download for free even if you click the subsidiary legislation. Wrong picture. But if you click on the subsidiary legislation pun sama, dia akan tunjuk what is the latest subsidiary legislation. Any revision, amendment, update, revision ke apa, dia akan bagi tahulah dekat dalam ni. And daily update is available. This one I screenshot last week. Nampak tak? On the 19th of July, tengok berapa banyak amendment yang ada. Setiap hari confirm ada new amendment, new changes, new revision or whatever else. Except for Saturday and Sunday lah. Saturday and Sunday biasanya tak ada update. Sebab staff dia pun tak bekerja, nak update macam mana. Okay. Alright, so the class learning method, we will conduct a live session only. Why we conduct live session? Because we want to encourage Q&A session. Ada yang tanya saya, ada recording ke? The answer is no, we do not do recording. Okay, except for the situation macam I have to postpone the class for whatever reason. I have a personal emergency ke apa lah kan. I have to postpone the class, so I will reschedule the class to another date. But if you cannot come to the live session, then it is fair for me to provide the recording or replay ke, ataupun I have to teach again ke whatever lah, macam tu lah. Okay, because unless the notification is given in an ample time, say 7 days, 7 days is an acceptable date. If I notify the participant within 7 days, which is an acceptable day when it comes to contract, then I do not have to do a replay ke whatever. But the other day, I notify within berapa days? 3 days before. We will do a replay session lah. Okay, so we will conduct in a live session because we want to encourage Q&A session and discussion. There was one time, one session saya buat, not IR class, saya buat untuk architect class. I provide an option lah for those recording lah, you can view it later. And then during the live session, there was only one participant attended live. We had 2 speakers, but the participant was only 1. It was very awkward. It was very awkward. The Q&A cannot be done. Discussion. They would like to watch the recording at any time, whatever time that they want to. So it kills the purpose of this webinar series lah, because we want to encourage this discussion, not to create such awkwardness. Okay, faham eh? That's why we don't do recording. Kita memang tak buat. Tak ada. Okay, participants are encouraged to read the law of Malaysia cover to cover. Remember, every single word under the law of Malaysia is gazetted. There is no such thing as section 1 until section 10 is important, section 20 to section 30 is not important. There is no such thing. Okay, notes will not be given. As we make direct to the law of Malaysia. Okay, now you understand the importance of law. Why you want to refer to notes? Because the notes slides does not cover the whole context of the class to Act 138. So even if you want the slide, it is stated under Act 138. We make direct reference. It's just that for our side, our class, for the presentation purpose, we cannot cover the whole individual. If you want me to teach and so things to type. So within this 3 hours, I just highlight things and teach you how to read the national land code. So note is available. It has been revised. The note, because it is no longer valid itself. That is the correct way to learn how to study law. Kalau tak percaya, cuba tanya lawyer. How did they study the law of Malaysia? Cover to cover. Okay, direct reference to the law. Dia tak refer nota ke fancy diagram ke apa, whatever. Tak ada. Okay. So notes will not be given as we make direct reference to the actual law. Refer to the actual law, jangan baca nota. Nota is not absolute. Law of Malaysia, the gazetted law is absolute. Refer to the law, yeah. Due to copyright as well, tendency of participant to read notes rather than the actual law, and considering that the law changes from time to time. So discussion, question sharing can be done in the WhatsApp group lah. If you want to do book tagging self-note, please do so. Okay, tips to study law of Malaysia. How to study law, and we are technical people in the construction industry. We are not readers, we are not lawyers yang baca or historian who reads. it is how our brain is wired. So whether you like it or not, you have to read the law cover to cover, because everything is going on in the construction industry is based on the law of Malaysia. It is not based on personal experience, word of mouth, or local authority kata itu ini, or whatever other reason. It is 100% based on the law of Malaysia. If the law said A, then A it is. Kalau orang lain cuba kata, tak, kau kena buat B. No, the law said A. Okay, it is absolute. You cannot challenge. Okay, do not read other people's note. Jangan baca nota orang lain, nota kawan ke, nota entah siapa-siapa. Jangan nota kat internet lagi, tak boleh percaya. Refer direct to AGC website. Yang ni, please visit AGC website frequently. Look for new update. Discuss with those who are sitting for exam, because this class, there are also people sitting for the exam. There are also people not sitting for the exam. Ada yang PEPC dah pun. But for candidates who are sitting for the exam, my tip is that please do a lot of discussion with fellow candidates and refer directly to the law of Malaysia. Jangan kata, senior saya kata macam tu, local authority kata macam tu, jabatan tu kata macam tu. Tak ada. Your answer should be the law of Malaysia said A, so A it is. If the law said B, then B it is. Okay, what about state law? Tadi ada yang soalan tanya berkenaan dengan ordinance. There was a question about yang tadi ordinance mana tadi? Sekejap, saya buka chat. Okay, when it comes to ordinance, it is a state law. It is not a federal law. Federal ni yang terpakai, federal is federal, and then outside the federal we have a state law. Where does the state law came from? Ingat tak tadi saya bagi tahu the history of federal constitution long ago. Each of this region, each of the state that we have today are different countries with its own sultan, with its own currency, with its own law. Okay, bila British datang baru dia combine, Persekutuan Tanah Melayu, negeri-negeri Melayu bersekutu, negeri-negeri tidak bersekutu, negeri Selat or whatever that they made it afterwards. But prior to that, each of these state was their own country. Negara yang tersendiri, sistem tersendiri, undang-undang sendiri. So, why there is a state law? Because this state law came from the existing state law that is available for the particular state. Okay, I will describe further about this, ya. Okay, mari kita masuk bab state law. Dekat mana yang cerita pasal federal law, state law ni? It is under the federal constitution. That's why I said everyone must read federal constitution at least once in a lifetime, so that you know how does this country works. Kalau tak baca memang tak tahu. Okay, Article 71 of Federal Constitution, what does it say? Okay, federal guarantee of state constitution. Can I give everyone to just go through this sentence for 1 minute? You have to read it yourself for 1 minute, then you, inilah sebabnya. Okay, I'll come back in 1 minute. Saya minum air sekejap, saya ada air kat tepi. Please read whatever is stated on the screen. Article 71. After you read this, then you know why. Okay, kejap. 1 minute. Okay, welcome back everyone. Right. Okay, let's continue. Mana tadi saya punya slide? Ha ni. Federal Guarantee of State Constitution. What does it mean? Meaning that each of all these states, before independence, before they merge to become Persekutuan Tanah Melayu or whatever afterwards, they have their own state constitution because previously they were independent on their own country. Okay, macam negeri Kedah for example, dulu ada apa kerajaan Kedah tua lah whatever, and then they form the modern state of Kedah. Lepas tu ada sultan dia sendiri, ada mata wang dia sendiri, ada constitution undang-undang tanah dia sendiri, semua dia ada undang-undang dia sendiri. Same goes to other state, they have their own existing law. So, when they want to merge to become a new country, masa tu pembentukan Persekutuan Tanah Melayu masa tu Sabah Sarawak tak masuk lagi. So, the federal government at that time, they give a guarantee to the state. Okay, hello all these states, now we merge. So all of us agree, tuan-tuan tanah semua, meaning that all these states sultan, we all agree that we remain our apa tu state constitution, except when it comes to federal matter. Okay, there are federal matter, there is a state matter. Okay, let's read this together first. The federal shall guarantee the right of a ruler of a state to succeed and to hold, enjoy and exercise the constitutional rights and privileges of a ruler of the state. What is the ruler of the state? The ruler of the state means sultan, raja, or yang di-Pertuan Negeri. Excuse me. Sultan, raja atau yang di-Pertuan Negeri. Okay, Majlis Raja-Raja Melayu. If I'm taking the context of Peninsula lah, Majlis Raja-Raja Melayu, they are the owners of the land. Sebab tu orang nak panggil Tanah Melayu tu, the apa tu, Malay state, Federated Malay States. Why the British call that? Because it is owned by the Malay Sultanate. As simple as that. Bukan saya, I'm a Malay, but the land does not belong to me. The land belongs to the Malay Sultanate, not me a Malay commoner, bukan. Okay, so ditulis, any dispute to the title, succession to the ruler shall be determined solely by such authority whatsoever. So, it clearly states, the federal guarantee the rights of a state ruler. You remain a ruler on your state, no worries. You want to create your own state constitution, go ahead, no problem. Okay, so how far does the existing state law can go before it can be cut down by the federal law? The answer is also under Federal Constitution, Article 73, extent of federal and state law. Okay, in exercising the legislative powers conferred by it on this constitution, A, Parliament may make laws for the whole or any part of the federation and law having effect outside as well as within the federation. Okay. B, the legislature of a state, meaning that the state ruler may make law for the whole or any part of that state only. So, say for example, I live in Selangor. So the Sultan of Selangor, he wants to make any law. It is only applicable within his territory. Di kawasan jajahannya saja. Okay, but for federal, they can make the law at federal level, meaning that federal at federal territories, including outside the federal territories, meaning that including other states, as long as it does not violate whatever is allowed under this constitution. Okay, I'll give an example. There are law that is similar the whole country, but there is also law that is not the same for every state. Lepas tu okay, saya bagi contoh lah pasal senang. Contoh pasal undang-undang syariah, dekat setiap negeri, it is stated in the federal constitution, the matter about religion is under the absolute power of the state ruler. Hak sultan negeri tersebut. So if they want to regulate a law, it is up to the state sultan lah. Up to the state level. So for example, if myself, if I roam around in Selangor wearing something like this, I'm not wearing a headscarf, it is not wrong for this. It is not wrong under the state of Selangor. Okay, sebab Selangor dia ada undang-undang agama dia sendiri. Kalau saya pergi dekat Kelantan contohnya, saya pakai macam ni, memang terus kena saman. And you cannot say, oi, tak adil. Saya duduk Selangor tak kena saman pun, pasal Kelantan jahat saman. No, you cannot say that. Those who say such thing, meaning that you did not read the constitution. The constitution guarantees, nampak? The federal guarantees the constitution of the state. Okay, so hak agama ialah hak ruler negeri masing-masing. Sultan raja yang dipertua negeri masing-masing. So kalau negeri Kelantan dia nak buat undang-undang, okay, semua perempuan wajib pakai tudung, it is up to them. 100% up to them. If I like it, I go. If I don't like it, I don't go. Itu je. It is your choice. Macam tu lah. So previously I had a project in Kelantan. So I understand the consequences. If I go there, I do not wear a scarf, then dia akan saman ke whatever lah. And I never blame them. I said, it is your right because I've read the constitution. I know that it is your right to impose any whatever religious law ke apa lah. Ikut-ikut dia lah. So for people who question, it shows that otak hang kosong lah. Nama dia hantar baca constitution. Macam tu lah maksud dia. So sebab tu saya keep on cakap, semua orang kena baca constitution at least once in a lifetime so that we will not make any dumb statements. Okay, alright, ni saya teruskan ya. Subject matter of federal and state law. Okay, dekat sini pun dia dah describe what are the matter under the power of the state, what are the matter under the power of the federal. Okay, macam isu berkenaan agama Islam, it is under the state law. Every state has a different syariah law. Tak sama. Sebab tu macam contoh siapa ada member Melayu ataupun siapa Melayu kat sini, kalau kita nak kahwin kan, dekat Selangor undang-undang dia siapa nak kahwin, mas kahwin dia minimum 300 for example. Dekat negeri Kelantan mungkin RM22.5. Lepas tu orang tanya, weh kenapa lain-lain lah? Oh Selangor ni kejam lah, Jais apa ni kejam lah, letak harga tinggi. No. Dalam Federal Constitution tulis, hal ehwal agama adalah up to the state lah, suka hati dia lah. You cannot compare to other state, tak boleh. Masing-masing lah. Okay, it is not an abuse of power at all. Kalau Selangor nak letak rate mas kahwin RM5,000 ke, tapi katalah dekat Kedah RM22.5. Lepas tu kita question dekat Selangor, Selangor kenapa tak ikut macam Kedah? You are being very rude to the state sultan lah, because hal ehwal agama is under his power. Betul tak? Baca constitution dulu, you'll be okay. Alright, subject matter of federal and state law. Yang ini. Okay, Article 74, it clearly put a line what are the things that the state can talk about or has the power on, and what are the things that the federal has the power on. So, dia tulis dekat sini, without prejudice, blah 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 blah, the federal list is stated in the first or third list in the 9th schedule. So nanti Federal Constitution you have to flip until the back, tengoklah 9th schedule tu dia tulis apa. Lepas tu bracket tu, the legislature of a state may make laws with respect to any of the matters stated under the second list of the 9th schedule. So what you have to do, you go to the 9th schedule, look at list number 2. That is the list under the power of the state. Okay. Yang ni contoh dia, ni saya dah bawa keluar dah. If you look at the picture on the right, list 2, which is a state list. What are the matter under the power of the state? Cuba baca. Yang ni dia punya state list tu panjang tau. Yang ni saya highlight about land saja because today's topic is about land. Okay, except with respect to the federal territory of KL, Labuan and Putrajaya, land including land ownership, landlord, tenant, registration of title, land improvement, soil conservation, land restriction, Malay reserve, or in the state of Sabah and Sarawak, the reserve ni yang tanah adat tu lah. Okay, permit, license about mining, about acquisition of land, transfer of land, kalau terjumpa harta karun or whatever, all these are under the power of the state sultan. Ataupun for the case of Sabah and Sarawak, iaitu lain lah. Okay. Kalau dekat Peninsula Malaysia, I'm taking the context of Peninsula, it is an absolute power of the state ruler himself. So nampak tak dia tulis land. So katalah saya bagi contoh lagi lah, senang negeri Selangor lah sebab saya duduk sini, senang cerita. So Sultan Selangor, dia ada absolute power when it comes to land matter, land title, land acquisition. What does this mean? It means the land belongs to him. When you pay quit rent, cukai tanah, kita bayar cukai tanah kepada siapa? Kepada pemilik tanah lah. We are just renting a piece of his land to build our house ke whatever. But the land is, apa tu orang kata, the absolute owner, the ultimate owner of the land in Selangor is Sultan Selangor. At any time he can kick you out. He can acquire the land without giving any compensation. It is allowed under the constitution. Okay, sebab tu orang kata jangan kurang ajar dengan sultan. Sebab he can kick you out. You are living on his land. Kenapa nak kurang ajar pula? Macam itulah maksud dia. So, for example, I live in Shah Alam. So, setiap kali saya tengah drive, tiba-tiba dekat belakang saya nampak ada lampu besar. Ada Sultan Selangor lah, dia nak lalu. Kan? Nampak je Sultan, saya terus ke tepi ke kereta saya. Sebab jalan tu jalan dia. The land belongs to him. So myself, I have to get lost lah. Make way to the owner of the land. He is the owner. Dia tuan tanah. Dia landlord. Because every year I'm paying cukai tanah to him. Kena kita pilih lah. Jangan kata, apa ni jom kita jadikan Selangor ni republic. Hello, you are living on his land. Nak bercakap benda macam tu. Okay, faham? Nampak ada kat sini. Lagi contoh macam tanah adat ni. Tanah adat macam saya kata lah, is it racist kalau kita nak beli tanah adat? I'm a Malay, I want to purchase tanah adat di Sarawak. Lepas tu orang Sarawak kata, weh, tak boleh. Sebab the constitution said so. Can I say that, racist? I cannot say that. It is not racist because it is stated under the constitution. Same goes to Malay Reserve. Okay, Malay Reserve dia tulis, this land, it is decided by each of the sultan lah. Tanah dia suka hati dia lah, dia nak bagi dekat siapa. So he said, okay, this land is only for Malay. Then it is only for Malay lah. Sama macam tanah adat Sabah Sarawak, it is only for katalah Melanau for example, then only for Melanau lah. Other race cannot purchase. Okay, situasi ni macam tu. Lagi apa lagi? Tanah, katalah Sultan buat tanah dia, dia ambil tanah dia, dia kata okay, this area I want to dedicate untuk saya bagi contoh saya ambil contoh senang lah. Dia nak buat hutan simpanan. Sultan kata, okay, this is my state. I want to make this area as hutan simpanan. I don't want anybody to do anything on this land. Terus diwartakan sebagai hutan simpanan. Gazetted lah, diwartakan sebagai hutan simpanan. Nobody can do anything on the land. Except if the Sultan said, okay. Suka hati Sultan lah sebab itu tanah dia. Saya kata, it's up to him lah. Okay, I give an example lagi ya. Ada case few years ago dekat Shah Alam. Ada satu community India, dia nak bina kuil. Okay, dia nak bina kuil lah. Dia dapat permission lah, dia jumpa MBSA ke dia pun mana? Yalah MBSA lah. Lepas tu dia dapat approval daripada PTG or whatsoever, Sultan no issue. So dia orang bina. Then there is a group of people, some extremists lah. From I don't know who are these extremists. Dia marah, dia kata, weh, ini tanah Melayu punya, ini apa ni. Lepas tu dia ambil kepala lembu, dia letak dekat that particular construction site of that queen, which is very rude lah. Okay, why this thing happen? You cannot claim, you cannot do such thing because the land belongs to the Sultan of Selangor. If the Sultan of Selangor said, okay, you can build a kuil there, then who are you to question? It is his land. You know, like, for example, I have this handphone. It is up to me to do whatever I want to this handphone. I want to throw it in the bin. I want to dip it in the water. I want to eat this handphone. It is up to me. It belongs to me. Other people cannot question what I'm doing with this phone. Macam tu lah. Okay. To prove my claim, the one that I just explained to you, ni, in front of your screen. Ni, state list. 100% under the power of the state. Clear? Alright. So what about if there is an inconsistency? Okay, thank you. If there is an inconsistency of federal law and the state law. Jawapan pun dah ada under Article 35. If any state law is inconsistent with federal law, the federal law will win. So federal jadi besar. Okay, in law competition, whichever is higher, it will win. So kalau state law kata A, tapi federal law kata B, the winner is federal law. Only for the matter that does not contravene the rights given to the state law. Faham Not everything Kena fahamlah the matter under state law and federal law Okay, so our practice is based on law. It is not based on personal experience, personal thought, hearsay, word of mouth, orang ni kata tu, orang ni kata tu, tak ada. 100% based on the text. Dia macam apa dia something gazetted. Read the law cover to cover. In law, every word is gazetted, diwartakan. Dia macam chop. Yes. Gazetted. To make a new law in Malaysia, it has to go through a very lengthy process, an act of parliament. A very lengthy process. You know, the parliament will debate. Dewan rakyat dulu. Dewan Rakyat debate, okay, jom kita buat akta ini, whatever, bawa masuk Dewan Rakyat, debate, dah pada 2/3 agree, naik ke Dewan Negara. Lepas naik ke Dewan Negara, dia melalui AGC. Lepas AGC, dia pergi Royal Extension. It must go through Yang di-Pertuan Agong. So, those people who say Yang di-Pertuan Agong ni buat apa? Dia tak ada kuasa. No? Every law in Malaysia must go through Yang di-Pertuan Agong Majlis Raja-Raja Melayu, representative of the native of Sabah and Sarawak, because they are the owner of the land. Itu kuasa dia orang. They are the owner of the land. There's no law can simply bypass without the approval of all these people. Yang di-Pertuan Agong, Majlis Raja-Raja Melayu, representative for the native of Sabah and Sarawak, because they are the owner of the land. Okay, clear? I hope this one is clear. Okay, jangan kata, oh, ni kerajaan lah buat undang-undang ni. No. The kerajaan did not do any law, any akta without the approval of the owner of the land. Okay, therefore, every single word matters under the law of Malaysia. Okay, for those of you, I think based on the registration form, I think about 30% of the participants are sitting for PCE exam. Ada yang nak ambil PE ataupun the Tier 1 yang the BM or IM route, whatever lah, yang towards PE. And the rest are PETC, ada juga graduate engineer. Alright, so for those of you who are sitting for the examination, please use these tips. When you provide an answer, you have to support it together with the legislative evidence. It is the same in actual practice. You cannot simply give an answer. When a client asks you a question, you give an answer without any legislative evidence, without legal evidence. Meaning that the answer just come from the sky. Tak boleh. You cannot say it is based on personal experience. Oh, you know, in my 30 years experience, hello, your 30 years experience is not valid. You must give an answer provided together with legislative evidence. Okay. For example, why do you need to apply for planning permission when you want to when you want to do any development? I repeat the question again. Why do you need to apply for planning permission? Why you need to obtain planning permission when you want to do any development in Malaysia, in this country? Why? Typical answer by people. Sebab local authority suruh, kita kena lah buat. Kita kena dapatkan planning permission, KM. Kita kena dapatkan KM sebab local authority suruh. Wrong answer. Kita kena dapatkan KM sebab, yelah, kalau tak ada KM, macam mana kau nak bina? Wrong answer. Kita kena dapatkan KM sebab, bomba suruh. Wrong answer. Plan Malaysia suruh. Wrong answer. All those answers are wrong. Many candidates yang ambil exam, dia bagi jawapan macam tu. Yang dah praktis pun sama, bagi jawapan macam tu dekat klien. As you know, I'm in PAM. I was a PAM counsel for 3 years, for 3 terms. We receive a lot of complaints from the public, from the clients, public about how architects are performing. Ramai yang tulis, sorry I know majority of you are engineers, but I'm talking about architects point of view. Ramai klien datang balik bagi feedback, arkitek tak tahu apa-apa. Engineer tak tahu apa-apa. Consultant semua tak tahu apa-apa. Diorang tak baca buku. Okay. The thing is, do not give any advice or any answer in the exam based on your personal experience ke apa benda lah. Macam saya cakap tadi lah. It has to be based on the law of Malaysia. Okay, back to the question tadi . Why do we need to submit forms? Why we need to obtain planning permission before you start any development in Malaysia? Jawapan yang saya bagi tadi semua jawapan-jawapan yang orang selalu bagi salah. Wrong answer. Sebab bos saya suruh, salah. Sebab YDP majlis suruh, wrong answer. All are wrong answer. The correct answer is according to Section 19 of Act 172. It prohibits any development without planning permission. That is the answer. I repeat again the answer. Why do we need to obtain planning permission in order for you to start a development? The answer is the only answer. Jawapan dia ada satu je. Dia macam exam PCE kan, dia bukan ada 10 jawapan. Jawapan dia ada satu je. That's the only answer because law is absolute. The answer is under Section 19 of Act 172, meaning that the Town and Country Planning Act 1976, it prohibits any development without planning permission. That's all. That is the answer. The only answer. Okay. So for those ni untuk tips siapa nak ambil exam lah, please use the professional answer based on the law of Malaysia. Okay, so 5-minute breaks before we dive deeper on National Land Code. For National Land Code, like I said, I will not cover the whole code because the code is so thick. There's so many things inside. Okay, 5 minutes break. If you have any further question, you can type in the chat box. I'm reading the question kat tepi. Question from Abang Nazimuddin tadi, ordinance. Ordinance is state. Peringkat negeri lah. Okay. No, ordinance it is not subsidiary legislation. Ordinance, dia punya level ya, when it comes to, I give an example for the state of Sarawak. Ordinance is equivalent to act in Semenanjung. Okay, ordinance is equivalent at the same level with act in Semenanjung. Dia punya level dia dekat situ. Okay, contoh macam Sarawak Building Ordinance. Lepas tu dekat dalam Sarawak Building Ordinance tu, dekat dalam dia ada anak-anak dia kan, part 1, part 2, part 3, lepas tu dia ada apa building bylaw kan dalam tu. It is part of the ordinance dekat belakang. From Xiao Kok Tong, dear Architect Amy, we will attend for PCE common paper examination, but we are not sure how to cite the bylaw section. Can you please guide us? Boleh, no problem. I can guide on common paper because the syllabus for common paper, PCE common paper is the same. The same with the architects exam because we are under the same ministry, Kementerian Kerja Raya. Boleh. But if you ask me technical paper, I cannot assist you on technical paper. Alright. Apa ni? Mouse aku bateri habis. Okay, say if there is a discrepancy between act and circular, which take precedent? The answer is whichever is higher. The higher one is act. Circular is at the very bottom. So act will win. Ya, kejap saya tukar bateri mouse. Tadi 5-minute break kan? Okay, I'll see you back in 5 minutes ya. I'll see you back in 5 minutes. Sempatlah saya tukar bateri mouse tu. Hai. Tu ni lah pula bateri mouse yang hilang. Nak habis. Okay, see you back in 5 ya. So take a break, 5 minutes break. Pergilah stretching ke minum kopi. I'll see you back shortly. Bye. I'm sorry everyone, bunyi saya batuk tadi. It was me. Okay, welcome back everyone. Okay, let's go into the National Land Code. The thing is, about National Land Code, you have to read it together. Actually, when you read any act, it has to be, you have to read the federal constitution first. Only then you can understand the act better. Because like I said at the very beginning tadi, the hierarchy of law, federal constitution is the highest one. Then below are the acts and codes. So once you know what is stated under the federal constitution, and then when you read National Land Code, whenever that you see the word state authority, state ruler, state authority, then you understand why is it that way. Okay, why do you need to get an approval from the state ruler? Why? The reason is because the federal constitution states so. The owner of the land, you need to get the approval from the owner of the land. Okay, that's why I start with federal constitution punya matter dulu bukan sebab saya potong National Land Code pendek. No, federal constitution is part of the National Land Code. Kalau tak nanti dia tak faham kenapa kena dapat approval state authority. Why from the state ruler is required? Nah, jawapan dia sebab under federal constitution lah. Okay. Okay. Yang ini saya nak transfer slide daripada laptop saya yang refresh tadi tu. Restart. Okay, sekejap saya upload sekejap. For the meantime, if you have a further question, you can type in the chat box. I will answer. Occasionally, I will have a look at the chat box and I will answer. Sekejap, saya transfer slide ya. Okay, there's a question from Abang Nizamuddin, suddenly it felt like being a lawyer after reading this law. How does it differ compared to law itself? The answer is our profession is 100% based on the law of Malaysia. Even our own act, our governing act. For example, for engineers, you have the Registration of Engineers Act 1967. For architects, we have Architects Act 1967. And then for quantity surveyor, they have the Quantity Surveyors Act 1967. In year 1967, there are these three acts were gazetted together because we are triplets. Okay. Even our profession, the something that governs us is also an act of parliament. Okay. So the first step already we are governed by the act of parliament. So it goes to other things in the in the construction industry. It is 100% based on law. The difference is that lawyers, they do not have the technical skill. For us, we have technical skill. Okay. The next question from Jayan. Based on Article 74, Parliament can make laws, correct? Is this law mean law at lower hierarchy than federal constitution like acts, codes, etc.? As per the constitution, will only can have amendment with the agreement from the Sultanate. Okay, for Act of Parliament, example, acts and codes at the second level, though, everything at the second level, even the National Land Code, Registration of Engineers Act 1967, Street Drainage and Building Act 1974, the formation, it is being debated in the Parliament. Okay, kita tambah itu, tambah ini, dan lain-lain lah. In the end, to gazette that particular act, it has to go through something known as royal ascension. If you read any law and any act, dia akan tulis date of royal ascension is 1st January 2024, for example. What is the meaning of this royal ascension? Meaning that any act of parliament that you want to create in this country, it has to go through with the permission, agreement of the royals, Malay Sultanates. In this case of Peninsular Malaysia, if you want to create a federal law, then it has to go through Yang di-Pertuan Agong, Malay Sultanate, and the representative of the natives of Sabah and Sarawak. Still have to go through that. The other term, royal ascension. Okay, smaller things like subsidiary legislation. For example, BM scale of fee. Apa dia BM? I'll give a simpler example. BM circular number 002, for example. It doesn't have to go through Yang di-Pertuan Agong Malay Sultanate. It is adequate at BM level, then go up to kementerian punya level. Minister, at ministry level only. Dia setakat itu saja. Banyaklah kalau benda kecil-kecil kan. Macam banyak nak update setiap hari pernah aku nak kena menghadap AGC. Sorry ya, apa? Okay, National Land Code or Act 828. If you feel National Land Code too long for you to mention, it is adequate if you just say Act 828. It means the same thing. This Act number is like, dia macam car plate number tau. It's a running number. Why National Land Code is known as Act 828? Kenapa Registration of Engineers Act has the number 138? The reason is because it's a running number. At AGC, they have a registry of act. Okay. The next available number will be assigned to a new act that is being gazetted. Macam kita punya apa, Act 138. Lepas tu ada Act 133 lah. The next available number, or sometimes there is an act that has been gazetted, lepas tu it has been repealed or deleted forever. Lepas tu ruang tu ada kosong. Okay, perasan tak? Registration of Engineers Act was gazetted in 1967. 138 nombor dia 138. Okay, cuba tengok Street Drainage and Building Act 1974. It was gazetted in year 1974. But why the number is 133? Dia macam belakang daripada Act 138. Because previously Act 133, the name was something else. And then probably that act was deleted, repealed. And then, ada ruang kosong lah. New act being gazetted. Okay, kau ambil this particular slot. The number assigned. Kita tak boleh beat. Kita tak boleh beat. Okay, Act 138 kita nak tukar lah kepada Act 999. Nak engineer nak nombor cantik tak boleh. It's a running number. Okay, in compliance to the Copyright Act 1987 or Act 332, no form of digital audio photographic is allowed either for distribution, display, or personal keep. This one is an agreement lah. We learn about law, so this one is Act 332. Okay, what is the function of the National Land Code? In any act that you're referring to, the function of that particular is stated at the first page after the index. Act 138 ke Act is situated at the first page after the index. The pattern is the same. So that's why I said you have to read cover to cover. You cannot skip any page. So when you refer to Act 828, the first page after the index, the function of this act is to consolidate the law in Peninsular Malaysia only, relating to these 5 matters: land, tenuership, registration of title, land dealing, revenue collection. Dekat mana yang ada tulis ni? The first page after the index of Act 828. Why is it important for you to read the law cover to cover? Because first you read the title, you know the act number, and then the date of royal accession, gazetted bila, masuk ke parlimen bila, semua dia bagi tahu dekat first page, dekat second page. And then there ada index. The first page after the index, it will describe number 1, what is the purpose of this act? Number 2, where does this act is applicable at? National Land Code is not applicable in Sabah and Sarawak. Clearly dia tulis dekat National Land Code, the first page after the index. Peninsular Malaysia only. Tapi dekat National Land Code tu dia tulis panjang lah. For the state of Selangor, Kedah, Perak, Pahang dan whatever. But it concluded as Peninsular Malaysia only. Yeah, it is very important for you to know this. Sebab I had one assignment in Sarawak before. It was bukan projek bina bangunan kapal, bukan. I was appointed by this client to ada pasal telecommunication tower lah, the illegal telecommunication tower and so on. So I was appointed to give an advisory service to this client. What are the things they should do to legalize all these towers, satellite dish gemuk tu. What is the procedure to legalize in the state of Sarawak? So I went there, and to my surprise, there was an architect. At that time, I went to this particular local authority in Sarawak. There was this one architect. He come to discuss about his development, his proposed development with the local authority. He brought the National Land Code. Orang dekat pejabat the local authority tu dia marah. I was witnessing that because it is it is disrespectful to impose a certain law at a different place. Faham tak? Dibawa National Land Code. Dan the pegawai kata, weh, kita kat sini, kita tak pakai National Land Code lah, pandai. Dia punya ayat dia lagi teruk daripada yang saya cakap tadi lah. I'm just rephrasing it in the nicer way. It is very offensive. Dia macam, ada arkitek daripada Sarawak datang ke Semenanjung tapi dia bawa Sarawak Land Code. Dia ni nak buat bangunan dekat Shah Alam, dalam Sarawak Land Code dia kata bla bla bla. Oi, it's very offensive. You do not even know which law applicable to which state. Okay? So baca cover tu apa? Peninsula Malaysia only. What are the differences between these two? Ada yang warna hijau ni from ILBS or whatever book publisher, and on the left Act 828. Apa beza dua ni? The answer is very clear. Cuba baca dekat cover. The one on the left in white color is Act 828. The one on the right, okay, tengok, cuba baca title dia. National Land Code, regulations and selected orders. The one on the right with this green color cover is not National Land Code. It is a compilation. I repeat it is a compilation of National Land Code together with its subsidiary legislation. Nampak tak? Dia ada tulis regulation as well. So the whole thing is not National Land Code. National Land Code is only the first part in this green book. Lepas tu belakang dia ada regulation. The last part ada orders. Dia compile the act together with the subsidiary legislation. Ya, faham ah? Ni beza dua dia. So if you want the free version, you go to AGC website. you download Act kan. Lepas tu if you want to download the subsidiary legislation, you have to click subsidiary legislation and download one by one. But these publishers, I'm not promoting ILBS, I'm not ILBS agent or whatever. I'm just taking any publishers cover from the internet je, random whatever it is lah. Okay. So dia bantu kita untuk compile siap-siap. Dia compile Act 828 together with anak-anak dia. Dia dah tolong kita compile. Instead of for us to download one by one dekat AGC, dia dah tolong compilekan untuk kita. This is the difference. Here. Okay. So in year 2020, the new National Land Code known as Act 828 replaced the old National Land Code known as Act 56 of 1995. So in version on the left, yang National Act 56 of, please take it, throw it in the bin because it is already invented. Pakai langsung dah benda ni. You have to pick one or you can download new one from the internet lah. The one yang on the screen ni is compilation. Yang nama dia baru Act 828 starting year 2020. So if we still have, I repeat again, if you still have Act 56 of 1965, buang atau sampah. Tak boleh pakai dah. Macam saya ada Act 56 of 1965, saya buat dia jadi mousepad. Sebab dia tebal, dia sedap. So dia tebal. Saya jadikan dia mousepad. Sustainable lah, recycle. Jadikan dia mousepad. Act 828 is a new one. Ingat siapa dia lama ambil buang atau sampah. Tak boleh pakai dah. Tak boleh pakai langsung. Okay, what about Sabah and Sarawak? Kalau kita kata National Land Code is for Peninsula Malaysia only, Sabah dengan Sarawak pakai undang-undang apa? The answer is this. Sabah dia ada Sabah Land Ordinance known as Chapter 68. Back to question Abang Nazibuddin tadi, apa beza ordinance ni, dia punya level dia setara dengan siapa? Ordinance ni, equivalent dia is to Act and Code in Semenanjung. Dia punya level dia. Okay, and in Sabah and Sarawak, they don't call Act 111, Act 999, dia panggil chapter. Chapter 1, Chapter 2, Chapter 999. Dia panggil the word chapter. So dekat Sabah dia pakai Sabah Land Ordinance 1930, Chapter 68 panggil. Dekat Sarawak dia pakai Sarawak Land Code, Chapter 81. Okay. So kena tahu which law is applicable where. So National Land Code, it consists of 447 sections and divided into 35 parts. Remember that I claimed earlier that I read the National Land Code cover to cover. I'm telling the truth. I read the National Land Code cover to cover. I read it twice. The first one I read Act 56 of 1965. I read Act 828 cover to cover again. Is it possible to finish reading National Land Code? Okay, I received a question. How long did I take to finish reading the National Land Code? The answer is I read it in 1.5 months. How did I do it? Okay, cuba tengok. This act contains 447 sections. Yeah, 447 section. Katalah I just put kejap. Okay, 447 section. Say if you read 10 sections per day. If you read 10, how long does it take to finish 447 sections? I use that method. Habis. Within 1.5 months, habis. Lepas tu I can skip, I can go to other act pula. Teruskan perjalanan baca akta lain. It is possible. It is possible. Okay. But you have to be consistent. You have to commit. Saya memang nak baca satu hari 10 session. Janganlah hari ni baca section ada 10, esok baca 2, lepas tu baca 1, memang tak habis. Dia mesti ada commit, nak baca. Okay. When do we use Act 828? Okay, this is the general sequence of development process. Okay, do not afraid when you look at my slide number sebab slide saya banyak diagram. Instead of text, banyak diagram. Alright, general sequence of development process. Like I said at the very beginning, pasal law of Malaysia and even how we arrange IR 2024 punya syllabus. In any development process, when you want to build something on a piece of land, the procedure is land, planning, building. It cannot be building dulu baru planning baru land. Impossible. Because the law of Malaysia said differently. Law of Malaysia said land, planning, building. What is the evidence? The evidence is that when you read Town and Country Planning Act 1976, that is about planning, it always make reference back to the National Land Code. Okay, and then when you read Act 133, which is the Street Drainage and Building Act 1974, it always make reference back to the Planning Act, which is Act 172 lah. Okay, so now in the development process, we have land, planning, and building. For today, we go on land. Pasal bunyi whistle. Sorry. Yeah. Oh, dia irritating lah bunyi whistle. Okay, so when it comes to land, what are the acts or the law of Malaysia that you have to read when it comes to land? Banyak. Land bukan National Land Code sahaja. There are so many acts involving land. We have the National Land Code. We have the Land Acquisition Act 1960. We have Land Conservation Act 1960. We have land banyak. Okay, for planning kita ada Town and Country Planning Act 1976, Federal Territory Planning Act 1982. Lepas tu kita ada subsidiary legislation, garis-garis panduan perancangan entah apa-apa, garis panduan perancangan itu ini. Oh, banyak undang-undang planning. Itu berkenaan dengan Environmental Quality Act 1974. EQ nak kena buat EIA apa, that is under planning. That is under planning. Under planning. Number one reference is always the Street Drainage and Building Act 1974. Lepas tu kalau dekat Sarawak ada Sarawak Building Ordinance dan lain-lain lah. Also kita ada subsidiary legislation, kita ada building bylaw, macam-macam building bylaw ada, tu ada Malaysian standard berkenaan dengan building. Banyak. So jangan ingat, oh I know about land after I've read National Land Code. That is not true. Banyak. Tengok yang tadi dalam AGCP website undang-undang the act sahaja ada berapa? Act ada 800 lebih. Okay, what are the important sections to construction industry community? The answer is all sections are important. There is no such thing as section 1 to 10 is important. Section 200 until 250 is not important. There is no such. Okay, they carry the same weightage. Masa dia digazetkan, tak ada lah apa tu, dia orang tetapkan, okay, yang ni penting, yang tu tak penting, tak ada. They have been gazetted at the same time and they carry the same weightage. Okay. If you miss one section, you miss the whole story. Yeah, ni real life. Real life situation. Okay, first let's go to the interpreting under section 5. Okay, dia tulis in this act, all documents of title to alienated land or lease and whatever, agreements and other documents relating to land granted, issued or entered into by or on behalf of state authority. Who is state authority? You have a copy of the National Land Code with you, right? Who is he? Sebab tu saya kata, if you don't read cover to cover, you will get confused when you just jump. State authority, siapa state authority? Dia kena baca daripada interpretation. Who is this state authority? So, under section 5, it describes who is state authority. State authority means ruler or yang di-Pertuan Negeri of the state as the case may be. Maksud dia, sultan lah. Sultan, ada setengah negeri dia tak pakai nama sultan, dia pakai nama raja. Contoh macam negeri Perlis. Mana ada sultan Perlis? Raja Perlis ada. Okay. Apa tu Negeri Sembilan? Negeri Sembilan tak ada sultan, dia ada equal level. Gelaran je lain. So state authority in this case means ruler lah. Dia boleh sultanate. Okay. Whenever that you found the word state authority under National Land Code, it means the sultan, raja atau yang di-Pertuan Negeri. That is what it means. So when you read cover to cover along the way, then you will understand it better. Oh, state authority. Oh, lepas tu jumpa lagi kata state authority. You immediately know ini maksud dia sultan. Okay. State authority in this case is the Malay Sultanate. Diorang ni lah. Nama state authority, they are the ultimate owner of the land in Peninsular Malaysia. Okay. And then the word state director. Who is state director? You must clarify all this interpretation first before you enter deeper into the act. Kalau tak, memang tak faham. Submit to state director. Lepas tu kita pening. State director. The state director of land and mines for the state appointed under section 12 includes deputy dan lain-lain lah dia punya staff. So state director means pengarah tindakan and include his staff. Because this state director is responsible for the whole land and mine office lah. Betul tak? Land mines of the, so who is land and mine of the state? Pejabat tanah dan galian negeri. State. Negeri. Example. Pejabat tanah dan galian Selangor. Pejabat tanah dan galian negeri Perak. Land and mine for the state. What is their duty? Okay, their duty is as the medium, as the middle person between the landowner, the ultimate landowner, who is the state sultan, raja yang di-Pertuan Negeri. I use the word state ruler, with the proprietor. Because the sultan cannot kutip cukai tanah. The sultan will not do that. PTG will act on behalf of the state authority. Faham eh? So this is the function of PTG negeri. They act atau with the sultan, raja yang di-Pertuan Negeri on the matters involving the land of that particular state. Because the sultan will not go knock your door, hello, aku nak kutip cukai tanah. Sultan tak buat macam tu. Who is state of the state? Maksud dia pengarah, pejabat tanah dan galian negeri dan anak-anak buahnya. Okay. Who are these people? Yang tadi lah. Yang PTG semua ni. Next. Land administrator. This is another word that you will always find in the National Land Code. This is the importance of interpretation. Who is a land administrator? Land administrator means land administrator appointed under Section 12 include assistant land administrator and whoever his staff is. Okay. At the last sentence, it states, having jurisdiction in the district or sub-district in which the land is situated. What does this mean? Jurisdiction in district or sub-district in which the land is situated means pejabat tanah daerah. Land office yang ada dekat daerah-daerah tu. Bukan negeri state yang paling besar tu. Yang ada kuasa di, apa nama dipanggil tadi tu, district or sub-district daerah-daerah ni, dia punya, the assignment is under pejabat tanah dan daerah. Okay. Example of land office. In Kedah. Dekat Kedah ada 12 land office. Pejabat tanah, pejabat daerah dan tanah Kota Stark ni, Kuala Muda, Kulim, Ubang Pasu, Baling, dekat Sek. Yang ni land office land office. Yang ni dia punya ni lah, these are the land administrator. Land administrator is the head of land office. State director is the head of PTG negeri. State level yang ni district level. Okay. What is the importance of these two level? It will determine where your submission will go to. If your land is this certain type, all your application will go through PTG of the state, PTG negeri. If your land is on this particular condition, your application and submission with regards to your land matter will go to PT daerah. You need to know these differences. Ada satu real scenario, saya pun nak muntah dengan cerita ni. There was this one land proprietor, pakcik lah, saya panggil dia pakcik. This pakcik appointed a consultant to build something on his land. So this consultant advised this pakcik, hello pakcik, this consultant has been appointed by this pakcik lah as the client now. Fee dah mula bayar. Lepas tu pakcik ni tanya, saya bagi nama konsultan ni arkitek lah because I'm an architect. So pakcik ni tanya, arkitek, so saya punya submission untuk tanah ni saya kena submit dekat mana? So this particular architect, not me bukan saya. This particular architect said to the pakcik, pakcik kena pergi PTG negeri dekat Kedah, kat Alok Stark tu. Ni tanah dekat Kedah lah. Kena pergi PTG negeri. So this pakcik naik motorcycle dia, naik motor kapcai dia, pergi sampai kat PTG negeri dekat Alok Stark, Kedah. Jauh daripada kampung dia. Sampai dekat situ dia nak buat submission. Sampai je dekat PTG negeri, the counter said, hello pakcik, your land, the submission shall not be at PTG negeri. your submission should go to pejabat tanah dan daerah. Bukan dekat level negeri. Negeri ni untuk kes-kes tertentu sahaja. Okay. Then this pakcik returned home so angry with this architect for giving him the wrong advice. You see, this is an example where our profession, not just for architects lah, including engineers, including town planners, whoever we are in the construction industry, is being looked down by the public because we gave the wrong advice. Why did you give the wrong advice? Because you did not read National Land Code cover to cover. That's it. Sebab tu je. If you read the law cover to cover, then you know that, okay, this certain situation you submit to PT daerah. Dia ni you submit to pejabat tanah negeri. Okay? Alright. So, I continue. Nanti lepas ni saya masuk what are the conditions for you to submit to land office and what are the conditions that you submit to PTJ negeri. There are two separate situations. Okay, next one, registry title. What is registry title? When you get a land title document, the first thing you need to check, is it a registry title or is it a land office title? From there, you know where your submission will go to. Okay, registry title means title evidence by a grant or a state lease. By any document of title registered in the registry under the provision of any previous land law. Apa benda ni susah nak faham dia tulis. Okay, tak apa. Kita teruskan. Next one, land office title. Means title evidence by a mukim grant or mukim lease or by any document of the title registered in a land office under the provision of any previous land law. Yang ni apa pula? Sekali baca macam tak faham kan? Okay. Apa beza dia? I highlight here. Registry title, terskip. Registry title, dia tulis title evidence by a grant or a state. I repeat again the word state. Negeri. Cuba tengok land office title. Means title evidence by a mukim grant. Kat sini dah tahu dah. If your land is under land office title, where your submission should go to, masuk level daerah kecil-kecil ni sudah. No need to go up to the state. If your land title document is under registry title, then your submission will go up to PTG negeri. You go to the capital of the state. Office dia dekat situ. Okay. Alright, next one. Section 13 talks about the delegation of powers of state authority to the state director. Sorry, saya pakai short form dekat situ, SA to SD. Can I give everyone 1 minute to go through this? Cuba baca ni, 1 minute. And then I will explain what it is. Because you have to read this first. Only then I can explain and you understand it better. Okay? I give you 1 minute to read what is stated on the screen. I'll come back in 1 minute. Saya minum air dah. Mana air? Ya, seminit lah. Okay, sorry. 2 minit. Saya nak pergi tandas sekejap. Ya. Okay, welcome back everyone. Sorry ya, saya pergi toilet tadi. Okay, we have questions in the chat box. I will answer. From Joyce Lim, may I ask what are the differences of the effect of amendment, updated, revised onto the act or laws, etc.? Okay, the differences, excuse me. Amendment, kalau there's a new amendment, dia akan keluar kan, Act A 1234, dia akan tulis A dekat depan tu, meaning that there's a amendment to be included in the particular act. A 1234, lepas tu dia ada sebahagian je, it's just a partial of it, whichever that is being amended. Okay, updated is when the amendment has been included in that updated version. Betul ke ayat saya? Meaning that the amendment has been included in. For example, like the Registration of Engineers Act, Registration of Engineers Regulation. If you click on the updated, dia dah masukkan tau yang ada amendment apa, section 34A ke apa tu. Yang about the single directorship, sorry, not section regulation 34 ke yang ada apa tu, single directorship. Okay, that's the difference lah. Okay, next one from Ang Wei Chian. Labuan is controlled under which law? The situation of Labuan, Wilayah Persekutuan Labuan, Putrajaya and KL, they are similar. Okay, they are similar because they are the federal territory. So for example, for planning, hold on Okay, so the situation for example, for planning in Federal Territory, they do not use Town and Country Planning Act 1976. Okay, if for example, if you're doing any development in KL, if you bring Town and Country Planning Act to DBKL baling tomato dekat kita, dia baling kasut dekat kita. Because Town and Country Planning Act 1976, it is not applicable in Federal Territories. It is stated at the first page after the index. For Federal Territories of Labuan, Putrajaya and Kuala Lumpur, when it comes to planning, the law applicable is the Federal Territory Planning Act 1982. Yes, but they're federal territory. So how you want to know federal territory, there's a different set of law. Okay, all right. So let's go to the delegation of powers of state authority to state director. Remember the word state authority tadi, maksud dia in the interpretation is dia tulis state ruler, maksud dia sultan, raja yang di-Pertuan Negeri. Correct? State director is the pengarah of PTG negeri. When we simplify the center, delegation of power from the state sultan to the pengarah PTG. Itu maksud dia. Okay. So the state authority, meaning that the sultan, can delegate his power when it comes to land matter. He give his power to PTG. Okay, I give a simplest example macam cukai tanah lah. Cukai tanah, the state authority did not go to you. Hantar email hi, I need this is Sultan of Selangor. I want you to pay this amount. Mind kita next section 6, director may act on behalf of the state. Okay, section 16 dia bagi tahu menginap pengarah PTG negeri simplifier the matters given from the state authority to him lah. Okay, next one, the power of state authority to make rules. This one is very clear. Dia dah bagi tahu state authority maksud dia siapa tadi? Sultan Raja yang di-Pertua Negeri. Sultan Raja yang di-Pertua Negeri. I use the word sultan lah, panjang lah nak sebut. Okay. Power of sultan to make rule because the land belongs to him according to federal constitution tadi, betul tak? So suka hati dia lah kalau sultan kata I live in Selangor, Sultan Selangor kata this land is for hutan simpanan. It is up to him. You cannot protest. The land belongs to him. Who are you to protest? Ataupun Sultan Selangor kata, okay, this area I want to make a Malay reserve land. Lantak dia lah, tanah dia. This land I allow for kuil Hindu to be built. It is up to him. It is his absolute power to give his land or to make anything on his land. Okay, the federal constitution guarantees that. Okay, and it is being further described under Section 14 of the National Land Code. Power of state authority, power of the Sultan to make rule whatever rule he want on his land. Dia macam saya bagi contoh handphone saya tadi, it's up to me whatever I want to do with my phone. This is my phone. Who are you to question me what I want to do with my phone? Macam itulah. Alright, next one. I jump to section 53, the alienation of land. Those section in between you have to read on your own lah. Nak cover 3 jam memang tak sempat. Section 53, alienation of land. What is this alienation? Dia alien yang ni ke? Nama dia alienation. Siapa ingat dulu back in 1990s kan dia ada brand Alien apa Alien Works ke apa dia panggil dia ada muka alien ni. Okay, the word alienation under Act 828 it does not refer to this type of Nurul Hidayah kata alien workshop, betul alien workshop. Dia popular dulu ada gambar alien. The word alienation under the National Land Code does not mean this alien lah. Bukan yang naik UFO tu, bukan. National Land Code ya. Let's come back to the main question. Who owns all the land in Malaysia? The answer is I already told you in the Federal Constitution for Peninsula Negeri. For Sabah and Sarawak, clearly stated under the Constitution, it belongs to the natives of the state. And they are being represented by the representative of the natives lah. Setiap kaum di Sarawak, kaum peribumi lah, dia ada representative dia. Dia ada Melanau ke, dia ada Dayak ke, Kelabit ke apa ke, dia ada representative dia, they collectively they make the decision. That is the reason why tanah adat selain daripada that particular race tu memang tak boleh beli. You cannot own, memang tak boleh. Okay, katalah saya, I'm a Malay, I'm a Bumi Putra in term of Federal Constitution, but if I go to Sarawak, I want to say, I'm a Bumi Putra, I want to purchase tanah adat. Memang kena sumpit, tak boleh. Tak boleh. Okay. It is not racist, but saya kata it is not racist because it is allowed under the Constitution and we agree to it to become the citizen of the country lah. Who owns all the land? Okay. Yang ni typical answer given by the public lah. Tanah dekat Malaysia, it belongs to federal government kot. Sekarang siapa PMX lah? Anwar yang own all the land in Malaysia sekarang. Salah. State government. State government is led by Menteri Besar. Menteri Besar punya. Salah. Local authority. Salah. Melayu. Salah. Orang asli. Salah. Developer, landowner. Semua salah. Salah sama sekali. Wrong answer. The correct answer is all of those study incorrect. The correct answer, all the land in, sorry, I should have put Peninsula Malaysia there. All land in Peninsula Malaysia belongs to the state Sultan. That is why it is called the Malay Sultanate. Why are you put the word, I'm talking about more into Peninsula Malaysia because National Land Code is applicable in Peninsula Malaysia only. So I'm talking about this Peninsula punya context. It belongs to the state ruler, or in other words, Sultan, Raja yang di-Pertua Negeri, whatever name that they use, but they are at the same level lah. It belongs to them. Okay. Where does it say so? Federal Constitution yang ni bukti yang saya dah tunjuk tadi lah masa presentation mula tadi. What about state without Sultan? Negeri Sultan atau Raja? Contoh Pulau Pinang dan Melaka. Dia tak ada. Mana ada Sultan Melaka? Sultan Melaka palsu ada lah. The Melaka Sultanate tak ada. Dia dah tak ada. Pulau Pinang pun dah tak ada. Because originally Pulau Pinang dia part of negeri Kedah lah. Lepas tu masa British masuk, lepas tu dia pajak ke apa, tu panjanglah cerita dia. Tapi Pulau Pinang dia tak ada sultan. Okay, dengan Melaka pun tak ada sultan. Who owns the land for these two states when there is no sultan, there's no raja, there's no tak ada yang apa, yang pemegang dia. Turun temurun itu tak ada. Siapa? Because they do not have sultan, they have their own national land code. Perasan tak? National Land Code Penang and Melaka Titles Act 1963 or Act 518. Again, I am not promoting ILBS. Saya bukan agent ILBS ke apa. I just take the photo from the internet. Okay, ingat Pulau Pinang dengan Melaka, they have their own national land code. Why do they have their own national land code? Number one, saya flashback ke zaman British administration, masa British colonization. the states in Peninsula Malaysia, kita ingat sejarah dulu the British they divided this region into 3. Negeri-negeri Melayu bersekutu, negeri-negeri Melayu tidak bersekutu, and negeri-negeri Selat, Strait Settlement. During that time, negeri-negeri Selat ada 3. Pulau Pinang, Melaka dan Singapura. Lepas tu Singapura dia dah ambil jalan dia sendirilah, lantak dia lah. So the remaining are Pulau Pinang dengan Melaka. So back then, all these negeri-negeri Melayu bersekutu or tidak bersekutu was under the power of British resident. Ingat tak? British resident. For negeri-negeri Selat, the Strait Settlement, Melaka, Pulau Pinang dengan Singapura dulu, they were under the British governors. Therefore, they were under a separate administration. British governors in the Strait Settlement and then British residents in this mainland lah. Apa tu, negeri-negeri Melayu bersekutu dan tidak bersekutu. Because they were under a separate administration before. So even after mereka, the land, the governing law of the land is not similar. Dia dah ubah lah. That is the reason why for Pulau Pinang dengan Melaka, they have their own national land code known as Penang and Melaka title. Another reason is because they do not have the state state ruler, maksudnya sorry, dia tak ada sultan atau raja, dia ada yang di-Pertua Negeri. Dia tak ada sultan atau raja. Yang di-Pertua Negeri can be changed every 5 years or whatever years. Macam sultan, you cannot simply remove sultan away. The title is inherited from one generation to another. Yang di-Pertua Negeri is not inherited. It can be changed from this person to that person, whoever the person is. Okay. Alright. So the answer, it is under the power of the federal. Sebab tak ada sultan. Tak ada turun-temurun ni, tak ada. Under the full power of the federal. However, the land matter is managed by the state government under the consent of yang di-Pertua Negeri. Okay. Kalau dekat negeri yang ada sultan, kita bayar cukai tanah tu sultan tu ambil. Dah tanah dia, kita ni penumpang je dekat tanah dia ni. Kalau macam yang YDP negeri, they cannot take the land, they cannot take the money to their pocket. Tak boleh because they do not own the land. Yeah, YDP negeri do not own the land because they are being keep changing every 5 years, 10 years or whatever years. Sultan tak boleh bertukar-tukar. Cuma bila sultan mangkat, anak dia akan ambil alih ataupun relatif dia ke within that same bloodline. So the property is passed from one generation to another. Kalau macam negeri-negeri yang tak ada sultan, yang ada YDP negeri, the possession of the land is not being passed into one generation to another because YDP negeri keeps on changing. Sebab tu it is directly under the power of the state, managed by the state government. Okay, under the consent of YDP negeri. Okay, now come back to the issue of the alienation of land. Apa ni alienation of land ni? Okay, under section 53, I simplify the word alienation. Alienation of land means disposed state land with registered land title issued to proprietor. Apa benda pula ni? Alright, I describe it in the simplest manner possible. Ni contoh Sultan Selangor. Sultan Selangor has this whole state of Selangor belongs to him. Kita bayar cukai tanah, pergi dekat dia, masuk poket dia. It is not wrong, memang tanah dia. Suka hati dia lah nak kuntik cukai. Okay, so now this Sultan, he has the right to alienate the land to any proprietor he wants to. The word is proprietor. Alienate ni dia memberi milik. Memberi milik. Okay, dia tengok Aimi ni dia tak ada tanah lah, kesian lah. Aimi come. I'm going to alienate 1 acre of my land to you as a new proprietor through PTG Negeri. PTG Negeri is acting on behalf. In other words, proprietor means the owner of the land on a piece. You can do transaction from one proprietor to another. You can sell the land to another proprietor. But it does not change the fact that the ultimate owner of the land belongs to the state sultan. Okay, you can do on the surface transaction. Aku jual tanah ni kat kau, kau jual tanah dekat aku. Whatever you want to do with the land once the sultan alienate the land to you. Alienate ni memberi milik. But if one day sultan said, Aimi, I want your land back. I want to acquire back your land. At any point of time, the sultan can do that according to federal constitution. He is allowed to do so. Okay. So, I repeat again, the word alienation means memberi milik. He gives the land to you, then you become the proprietor. The word is proprietor, faham? Once alienation has happened, a land title document will be issued. Land title document ni yang orang dah sebut geran-geran apa benda tu, the word is not geran, the word is land title document. It's a document that states the location of the land, the size of the land, the document tu. Lepas tu ada nama lah pemiliknya siapa, 1/3 ke 2/3, whatever name lah. Proprietor. Okay? So it is the responsible of the proprietor to pay the quit rent to the state authority annually ke monthly ke ikut syarat dalam land title document tu lah. And the payment is to be done through PTG. Sultan tak kutip duit. PTG will act on his behalf. Okay, apa maksud alienation? The Sultan give the land to you. Okay, I give, yang ni dalam bentuk orang, dalam bentuk orang. I give in the form of geografi punya manner lah. Okay, ni negeri Selangor. So macam situasi tadi, Sultan tengok, ya ini kesian lah, dia tak ada tanah kau, kesian lah ini. Aku bagilah kau duduk sini. So I alienate this land to you. So the brown one is alienated land. Kalau tengok peta ni besar tanah saya dapat. I alienate this land to you, and the evidence of this alienation of land from the Sultan of Selangor State Authority to me is this land title document. Ya, lepas tu dia tulis setahun kena bayar berapa kat Sultan untuk cukai tanah. Meaning that I can occupy the land with the conditions set in this land title document. But however, every year I have to pay to Sultan lah, State Authority, through PTG. Faham lah? This is the meaning of alienation. So once a land is alienated, land title document will be issued. Example of land that has not been alienated are the lands without any land title document. Macam tu je nak tahu. Yang ni tanah ni dah diberi milik oleh Sultan kepada sesiapa ke? If there is no land title document, meaning that the land is not has not been alienated yet, Sultan still holds the land. Yeah. Tak ada break lah, kita teruskan. Next one, classification of land under section 51. Okay. Under the National Land Code, there are two classification of land. Number one, land above shoreline. Number two, foreshore and seabed. Why I'm highlighting this? Because this will determine whether it is a registry title or land office title, and it will determine whether your land application will go to pejabat tanah daerah ataupun pejabat tanah negeri. Which one will go? Which one will go to which? I repeat again, classification of land ada dua. Land above shoreline, foreshore and seabed. So I made a dumb diagram using PowerPoint. Saya kita kalau saya nak buat diagram cantik, I can use Photoshop, Revit, I can use all those software lah. Tapi ni sebab PowerPoint lah, I use whatever tool lah yang ada dalam PowerPoint, sebab tu dia buruk. Betul lah, saya buat ni pakai rectangle, pakai apa tu, triangle. Okay, anyway. So what's the meaning of land above shoreline dengan foreshore and seabed tadi ya? So I give a diagram like this. Land above shoreline is any part of the land of that particular state before it reach the mean low water mark. Nampak tak yang saya tulis number 1 tu, land above shoreline. So land above shoreline pula, it is divided into 3. Town land, village land, country land. Yang kita bina KLCC ke, kita buat rumah ke, perumahan ke, pencawang, TNB ke, whatever lah. Those are all under classification of land number 1, which is land above shoreline. Okay, and land above shoreline is divided into 3, town land, village land, country land. I will describe this further later. Okay, then sampai dekat mean low watermark. This mean low watermark is a fixed line. They are fixed. It does not depend on air pasang, air surut ke tak. It is a fixed line at this particular point. It is not being determined so why our the mark is the reference point. When part of the land in the territory of Malaysia up to